Welcome to the Legalpreneur Podcast. I'm your host, Andrea Sager, and I'm dedicated to covering common legal issues for small business owners and just how some of the world's most elite entrepreneurs have handled legal issues themselves. In true attorney fashion, the information in this episode is not legal advice. This is for informational purposes only, and you should always consult with your attorney before implementing any of the information. Now, on to the show. Hello. Welcome back to another episode of the Legalpreneur Podcast. I have today's solo episode, which is really exciting for me. I'm able to nerd out because we are talking about the most recent Supreme Court ruling, which just came down literally days ago. It is actually something that is very, very, very important for small businesses like yourself. So make sure you're paying attention to what is going on today because it just makes trademarks so much more important. And I can't believe this came down because I know a lot of business owners are going to be freaking out. So make sure you pay attention. Make sure you shoot me an email if you need help with trademarks. And of course, you can always text me 832-225-3164. If you need help with trademarks or if you just want podcast updates, just shoot me a text and let me know what you're wanting help with. But of course, you can always shoot me an email. Let's get into it because it's really important what the Supreme Court just ruled. So with my clients, I have a very frank conversation with them when it comes to trademark infringement. So my clients are small business owners, typically not, billion-dollar businesses. I do have some million-dollar businesses that I work with, but most are in the six-figure range. Because of this, most of the time, we're not too concerned with a trademark infringement lawsuit. And there's a couple of reasons for that. Number one, it's so expensive to sue for any particular reason. And a lawsuit means you're going to be spending a lot of money. So if a client is thinking about suing somebody or if they think they might get sued, then we kind of lay out the reality of things for them. Like, okay, yeah, maybe this is probably trademark infringement, but are you going to get sued? Well, this is the considerations that the other party is having. So this is the reality of it. Maybe you won't get sued as long as you do stop using the infringing mark. And that's typically what happens with trademark infringement issues. So if you're a client of mine and you're using an infringing name, and sometimes we'll run a trademark search for a client and it comes out that they are infringing on somebody else. And I have to have that conversation with the client. And I say, look, you are currently infringing on another business. I can't force you to rebrand, but my job is to arm you with the reality of the situation, and then you choose to do what you want. So typically, I tell them, hey, look, this is infringement. You're a small business. If you stop using the name now, then chances are they won't sue you for lost profits. So that's the reality situation that I have with clients. So that's one side of it. The other side of why trademark infringement suits in particular are so, I'm not going to say rare, but why they don't happen very often is because it's hard to actually get damages. So when I say damages, it's hard to actually get a monetary award for trademark infringement. And that is because there's certain things you have to prove for trademark infringement in order to get a monetary award. And it's not easy to prove. And in order to prove that, you actually have to spend more money. So more money, it's basically a risky investment to try to prove the damages. And it's not a guarantee that you would actually be awarded those damages. So, there's a lot that goes into a trademark infringement suit. Just know that they don't happen very often, but because of the latest Supreme Court ruling, they might happen more often. Up until the Supreme Court made its ruling, there was a circuit split. So when I say a circuit split, basically half the federal courts in the United States ruled one way and the other half ruled the other way. Well, because there was this split and the courts couldn't agree, that's why the Supreme Court of the United States got involved, because they can't have all these different lawsuits. And that's when you have forum shopping, so court shopping. So if a business can file a suit with a couple of different courts, they're going to look at, okay, who actually would side with us? Looking at the past, who would side with us going forward? So that's called court shopping or forum shopping. So the Supreme Court likes to avoid that at all costs. So that's why they got involved in this particular case. Getting to it now. Before this ruling, some of the courts said it had to be willful infringement in order to be awarded profits in a trademark infringement suit. So that means the infringing party had to know that it was infringement and they still continued infringing. So maybe the other party reached out and said, hey, look, this is infringement. You need to stop. And the party gives them a chance to make things right and stop the infringing use. Well, willful means that they were given the opportunity to stop and they didn't. Or maybe they knew from the beginning that it was infringement and they still did it anyway. That is typically what's considered willful infringement. Now, the Supreme Court last week said willful infringement is not required to award profits in a trademark case. That is pretty big news if you are a business owner. So a lot of times, like I said, there wouldn't be a trademark lawsuit because it's so hard to collect damages, it's so hard to prove damages, and because of that, it would steer a lot of companies away from actually suing for trademark infringement. Now that the Supreme Court made this ruling, all the courts have to abide by this because they said willful infringement is not required. Now you better believe that there are going to be a lot more trademark infringement lawsuits. So if you do not have your trademark game in line for your business, this is something you need to visit now. Basically, if somebody got sued for trademark infringement and they said, oh, well, I didn't know it was infringement, or even if you didn't do the correct searching, you didn't use your trademark attorney, you didn't get the proper guidance, typically they would rule that that's not willful, it doesn't matter, you don't have to pay your lost profits and damages. Well, now basically it's saying they don't care if you were just consciously ignorant of the fact that it was trademark infringement. They don't care if you don't do the proper searches. They don't care if you don't consult with a trademark attorney. The courts do not care because willful infringement no longer has to be proven in order to get lost profits and damages. So because of this, businesses are going to be pursuing those that possibly it wasn't worth it in the past to sue them for infringement. And now it is worth it. So now they're going to be filing more lawsuits because they're going to get damages. So keep that in mind if you're somebody who's just been like, oh, I'm just a small business, nobody's going to care about me, or, oh, I'll just plead ignorance, I didn't know. Well, guess what? Number one, ignorance is no defense of the law. Number two, they don't care. If you're a business owner, you are automatically held to a higher standard. If you're making money in any way on your own and you're not somebody's employee, you are held to a higher standard than your average individual. So you are responsible for so much more now that you're a business owner. So you have to make sure you're taking care of all of the different aspects of your business. One of them being the legal side of your business, which I like to talk about here. And even now, more so, it is even more important to be concerned with trademarks. So if you are somebody that has not protected their branding with federal trademark registrations, it is time to do that now. If you hear this podcast and you're like, oh my gosh, yes, help me out, go ahead and shoot me an email, mention this podcast, and we'll have just, some little podcast deal for trademarks. So shoot me an email, Andrea@andreasager.com. Let me know that you listened to this podcast and you are now freaking out about trademarks, and we will get you taken care of. Alrighty, so that's it for this episode. I just wanted to have a quick down and dirty episode about the latest Supreme Court ruling. I mean, I think a lot of people are pretty surprised about this, but you're a business owner now. You have to be taking care of all sides of your business. whether you are aware of the law or not, and that's why you need an attorney in your corner. Alrighty, go ahead and let me know what you think. Screenshot this, share it to your Instagram stories, and shoot me an email if you need help, and don't forget to text me. Alrighty, I'll see you guys later. If you found this information helpful, I would be so grateful if you could share it with a fellow business owner, and it doesn't cost anything to rate, review, or subscribe to the show. Your support helps me reach more listeners, which allows me to support more business owners in their entrepreneurial journey. I'll see you next episode.